Ladies and gentlemen, dear colleagues and friends of the Käte Hamburger Center on Law as Culture. It is a great pleasure for me to welcome you to today's lecture in our forum. Our speaker tonight is Christa Rautenbach. She is professor at the Law Faculty of Northwestern University, South Africa. The topic of her talk is the plurality of marriage laws, exploring the viability of a single marriage code for South Africa in a comparative perspective. To gain insight into the plurality of family law in South Africa really is a fascinating endeavor. The topic is of especially great interest here in our center, Law as Culture, where we are currently in the phase of focusing on the relationship between law and community. South African society is constituted of very diverse communities with their particular religious, cultural customs and practices. Its legal system is also, for historical reasons, characterized by a considerable legal pluralism consisting of state and non-state laws. Especially in the field of marriage law, this plurality could be considered as a celebration, really, of diversity. But as we will see, Christa Rautenbach will show us, it also creates substantial challenges, I think. One in particular being the tensions between equality and cultural rights, both guaranteed by the Constitution. How to achieve family justice in diverse cultural and religious societies is a highly topical and vibrant theme globally. South Africa is really not the only country wrestling with the task to manage diversity in family law. Many formerly fairly homogeneous societies have become increasingly diverse, here also in Europe and Germany, where legal systems are now trying to accommodate family normativities of diverse religious and cultural origins. So comparative perspectives often open up great potential. And today we are curious to learn from Christa Rautenbach how to overcome the challenges of plurality in marriage law by creating a single marriage code for South Africa. And who could be more expert voice on this than Christa Rautenbach? She is a member of the advisory committee of the South African Commission on Legislative Reform, working on the Single Marriage Statute project. And since 2020, she is chairperson of the committee, that is, drafting the bill. However, this is but one of her many significant activities and achievements. And before I give the floor to Christa Rautenbach, it is my pleasure to introduce her and to point out some more of her very impressive accomplishments. After graduating, she first worked as a public prosecutor at the Department of Justice before then becoming law professor, and in 2005 being appointed at the law faculty of Northwestern University, where she is now. Christa Rautenbach holds numerous positions in various prestigious organizations and commissions, not all of them I can add up here, but among others, she is honorary treasurer of the Society of Law Teachers of South Africa, and very importantly, she is ambassador scientist of the Alexander von Humboldt Foundation and former president of the Alexander von Humboldt Association of South Africa. Furthermore, Professor Rautenbach is a member of the advisory board of the African-German Network of Excellence in Science. And to top this off, if this is possible, only a little while ago, while she was already with us here in Bonn, she was inaugurated as a member of the Academy of Science of South Africa, the National Academy of Science. So Christa is also on the editorial board of several leading journals. She has published widely and internationally many articles and books, among them two leading publications that I just want to mention, the Introduction to Legal Pluralism in South Africa and the Law of Succession in South Africa. And since September this year, Christa is a fellow at the center. So we are very happy to have you here with us tonight, Christa, and the floor is yours.
Thank you very much for that kind introduction. I may just mention that my term ended as Ambassador Scholar of Alexander von Humboldt in May this year. So you can only be appointed for 2 terms. I would also like to express my gratitude to Professor Käte and also you, Nina, and also the rest of the team at the center, which made this fellowship possible and is really giving a lot of support even in difficult circumstances. Certainly a fellowship which I will not soon forget because it was exceptional times. And it's really, for me, a pleasure to experience the whole COVID situation in Germany. So nobody needs to feel sorry for me. I'm 100% okay here in my little flat, and also going to my office every now and then. As Nina already explained, the title of my presentation is Plurality of Marriage Laws, Exploring the Viability of a Single Marriage Code for South Africa. And I will do a little bit of comparative analysis, but that part of my research is not that far advanced yet, except for what we did for the Law Reform Commission. And I might just add that the Law Reform Commission is scheduled to sit tomorrow, and we have tomorrow at German time, 8 o'clock, to discuss all the reports of the Law Commission and all the various committees. So we will know by tomorrow afternoon if our report has been accepted and is ready for publication or not. So let me just, for those of you who don't know much about South Africa, give a little bit of background. We are a diverse nation of about 58 million people. Of course, these statistics aren't that reliable because the last census we had in 2011, so this number could actually be much more. And what is also important is that South Africa still uses the pre-democratic racial classifications in the statistics. And the reason for that is because South Africa has black empowerment legislation, so it is still important to know in which category you fall in order to get the advantages of that legislation. So if you look at the numbers, we are at this moment about 80% black people, about 8% colored people, and this is an interesting classification because it's not really a term that people know much about, but color refers to the mixed races of South Africa. So it would be, for example, the offspring of a black and a European person. Of course, it is not so easily to put you in this category or not, because there are a lot of other people that falls in this category. It's a lot of self-identification. So people would say, I am a colored or not. I suppose I belong to the 8% white people, although I always joke and said I had my blood tested a while ago, and it turns out I am not 100% white, but I do have African influences as well. And there's also the minority of about 2 to 3% Asian and Indian. It's also interesting to note that we have official languages, 11 of them, but mother tongue speakers is the majority, 24% Zulu, 17% Xhosa, and 12% Afrikaans. And Afrikaans is, of course, also my mother tongue. 9% Sepedi. English is only in the 5th place together with Tswana at 8%, and then the rest of them. Now, it's impossible for all these languages to be used in the public sphere, so there is a non-official policy to follow English in all the public spheres. Now, religions is also quite diverse. We have in the top 5, 80% Christianity, and that is mostly Protestant, 5.4% traditional African, about 2% Muslim, about 1% Hindu, and a very small minority Jewish, and then other religions. Now, Nina also already mentioned this. We have a mixed pluralistic legal system, and that consists of state and non-state laws, and all of them are subject to a higher norm, the South African Constitution. And this is quite interesting because it is not international law that is the higher norm as in many of the European countries. Now, the plurality of the South African legal system and the 1996 Constitution, as I said, declared itself as the supreme law. So that stands in Section 2 of the Constitution. And I'm really sorry for all the legal jargon that I'm using, but I mean, having a background as a lawyer, that is inevitable. So we have then what we call the common law. So it's not the common law that is similar to English law, but it is a unified law. It is the law common to South Africa, and that is our state law. We have the customary laws. They are diverse, and it's also state law. And then we have the non-state law, which is religious. Now, customary law is actually quite important, the middle one, because South Africa ranks 28th in the list of countries with rural populations. And although there are no reliable statistics, it is estimated that more than 16 million people live in former homelands under traditional authorities, with some parts of their personal lives regulated by customary law. Now, if you look at the sources of those three main categories, the common law, as I already said, that's the Western norms, and it is actually adapted 17th century Roman Dutch law, and that was in operation in the province of Holland. And it remained the law of South Africa when the Netherlands codified and united. And then, of course, since the 1800s, we got English influences because then South Africa became an English colony. So that is actually the main part of the South African law. Then that is also added to statutes, case law. We follow the principle of stare decisis. So courts have to follow the decisions of higher courts. We have a few authoritative textbooks, and that is the law of general application. So it means the courts must take judicial notice of it. Then we also have customary laws, as I said. Those are the indigenous laws. The authority vests in the communities. And we distinguish there between official law and living law. Now, official law are those customary laws that are already taken up in statutes, case law, and anthropological textbooks. And of course, the living laws are those norms that are not codified in those official law sources. And they may differ from community to community and also from the official version. Now, the 96 Constitution recognizes customary law, and it says that the courts must apply it when it is applicable. And that is, of course, your rule of choice. And it's not so easy to determine what the applicable law is if it is living law. So courts take usually judicial notice of the official law, but if there is a party that says, listen, this is living law that must apply, then usually you need expert evidence. And when I say expert, it doesn't really have to be an expert. It can also be somebody respected in the community to talk about it. It can be an anthropologist. So the options are very wide. And then with regard to religious laws, those are religious norms followed by the religious communities. So it's just in the personal law sphere, and that is, for example, Muslims that follow Muslim law in South Africa. Now, although this is not a recognized legal system, we have piecemeal recognition in case law, and I will refer to a few examples. Now, the court usually treats this as foreign law or custom, and usually they need evidence in court to prove what the content of those rules are. Now, just a little bit about the status of customary law. It is quite interesting that the courts almost immediately took the viewpoint that indigenous law or customary law is now equal to the common law. And although they are not really the same thing, because common law is a law of general application, customary law is just a law that is applicable in certain circumstances, it was very adamant that from the start that customary law cannot be looked at anymore through a common law lens, but must be looked at through the constitutional lens. Now, this is a little bit difficult to do because if you consider our courts work in terms of common law and not customary law, I think it's inevitably going to happen that they do use common law principles to look at customary law, but at least they pay lip service to it and they said it should not be done. It was reiterated in a few cases already, but I refer just to these two examples. Both the common and the customary law sit under the umbrella of one controlling law, the Constitution, and that is more or less the theme in all the decisions where customary law was dealt with. Now, living customary law is, of course, the other interesting phenomenon. How do we deal with living customary law? There are no statutory provision that tells us how, but the course also gave direction on how this could be done, and I decided to take this quote from the Beck case. It is one that dealt with the law of succession in South Africa. It dealt with the rule of male primogeniture in customary law, where it held that this rule was unconstitutional because it discriminated against women and other children of a deceased, and it struck down the rule of male primogeniture, and it said, well, in this case, we are going to apply the Interstate Succession Act, which is a common law act. So that's also one example where the courts looked or used a common law statute to solve the problem of the rule of male primogeniture. So what the court here said about living customary law is, and I will read the quote, the official rules of customary law are sometimes contrasted with what is referred to as living customary law, which is an acknowledgement of the rules that are adapted to fit in with changed circumstances. The problem with the adaptations is that they are ad hoc and not uniform. So what the court here says is, if it's, for example, a Tsonga rule, customary rule that comes to court, and the court adapt that particular rule of customary law, it will be only the rule that applies to the Tsonga community. So that rule may not apply uniform to all other communities. And that's the whole thing about customary law, is that customary law is very localized and it's linked to communities. So changes brought about by court decisions will not necessarily change the whole face of customary law, but only for that particular community. And that particular case, as I said, dealt with interstate succession. So the court explained, well, in the future, it's going to create hardships and changes in society. Now, the plurality of marriage laws. This is just a brief overview to show you how plural the marriage laws at this moment are in South Africa. The first column is the common law marriages or the civil marriages, which we like to use the term civil marriages, and that is in terms of the Marriage Act 1962. So as you can see, this 1962 Act is actually a remnant of the apartheid era. So that is one of the reasons why that wasn't amended all the time to accommodate all the new types of marriages, but new marriage laws ensued. That act is available to everyone. It contains statutory formalities for marriages. It's only available to heterosexual couples. So when I say to anyone, I mean anyone in South Africa except if you're same-sex. So it is only allowed for monogamous marriages. Registration is a validity requirement, and a marriage officer must be involved. Then we get the second category. With that particular act, Recognition of Customary Marriages Act, came into operation in 2000. It is applicable to indigenous people. So a few commentators have said, well, it's actually then a racial act because you must be black in order to use this act to conclude a marriage. It has formalities in terms of customary law, which is also an interesting phenomenon. It says the marriage must be concluded in terms of customary law. So that gives rise to interesting situations. In every case, in order to decide if a marriage was valid or not, you need to go to the customary law of that particular community to ask what are the requirements for a valid marriage, and then you decide if this marriage is valid or not. And it has created problems. There are court cases about that. And one of two of the requirements that creates a lot of problems is the payment of lobolo, that is a payment the husband and his family makes to the family of the wife in order to hand her over to the family. And that's also the second requirement in many of these types of marriages, is that there must be a formal handing over where it is watched by the public. So if those two formalities have not been complied with, it's usually an scapegoat for the man when the marriage is dissolved. And he would either say, oh, well, I haven't paid the full lobolo yet, or there was no formal handing over in public, so this is not a valid marriage, so she's not entitled to any type of compensation. It is only available to heterosexual couples, but it can be polygamous. Registration is required, but it is not a validity requirement. So if you didn't register, it can still be a valid marriage. And the marriage officer is not involved, it's just the two families. Then the third category came into operation in 2006, and that's the Civil Unions Act. It's also available to anyone. It also contains statutory formalities. It's actually quite similar to the Marriage Act. It allows for same-sex and heterosexual couples, and you can either call it a marriage or you can call it a union. That is your choice. It's monogamous. Registration is also a validity requirement, and the marriage officer is also involved. And then the fourth category is not marriages that are recognized, but there has been piecemeal recognition of certain consequences of those marriages. And it's usually religious communities and mostly followed by the Muslim community. The other communities, Hindu and Jews, normally conclude a dual marriage where the one is in terms of their religion and the other one is then a civil marriage, but it is to the same person. Statutory formalities are therefore not applicable. Only heterosexual couples do this. It can be polygamous. Registration is, of course, not an option. And there is no marriage officers involved. It's sometimes the imam if it is a Muslim marriage. And the last category, the life partners, they are also unrecognized at this moment. There are also case law that gives piecemeal recognition to some of the consequences. There can be a tacit agreement or a written agreement between the parties, or there can be nothing. There are no statutory formalities. It can be same-sex and heterosexual partners, usually monogamous. No registration requirements because it's not applicable, and the marriage officer is also not involved. So you can see by looking at it just like this, there's definitely not equality between the different types. And the Constitution says everybody must be equal before the law. Now, why has this happened? The culprit is, of course, partly, but not only, Section 15 of the Constitution, because this Constitution allows for the recognition of marriages concluded under any tradition or system of religious, personal, or family law. And because of this, this section is often used when somebody says, listen, I want our marriage to be recognized, if it's a Muslim marriage or a Hindu marriage or a Jewish marriage. So Section 15 is used by the communities to tell government, listen, you need to recognize our types of marriages. So what happened is, and this was exactly what the Muslims did with regard to Muslim marriages. It's not new on the table. We had it long ago that Muslims said, listen, we want our marriages to be recognized. But early cases refused to do it. And I think it's similar in many of the European jurisdictions. It was not recognized because of the fact that it is potentially polygamous, and that is regarded against public policy. 1994, the Constitution came in. It guaranteed equality based on religion and marriage, and also equality, and also celebrated diversity. So it was not longer possible to use this argument to say that polygamy is against public policy. And of course, customary marriages are recognized and they allow for polygamy. So the public policy had to change. And the first case was Roland versus Edwards. It was in the Cape High Court. The wife asked the court to enforce a Muslim marriage contract when the husband served a talaq, divorce on her. So here the husband disputed the validity of the contract because the marriage was invalid in terms of South African law. The court held that the constitution changed the public policy and that the contract was valid even if the marriage was not recognized as a valid marriage. So he used the law of contract to say that this contract was not against the public policy and the husband had to abide by the provisions of that particular contract. And in 1997, the next case was in the Supreme Court of Appeal. There, a husband was negligently killed in a car accident, and the common law allows for a claim of compensation if a breadwinner is killed by an offender in a negligent act. So the problem was she was not able to claim this because South African law did not recognize this as a valid relationship in terms of this duty to support in South African law. But what the court did is it also said the man had a duty to support her in terms of this Muslim contract. And that contract was a valid contract. So that duty to support was also a valid duty to support. And then her claim succeeded and the offender had to pay her compensation. Now, the two cases are examples where the common law was developed to accommodate a Muslim marriage contract. So it was no longer against the public policy because it allowed for polygamy, but the court still did not recognize the validity of the marriage. So it's a little bit of legal gymnastics to come to a position where a wife gets protection from the law. Now, a few cases then followed that also developed the common law, but in this instance, statutes to accommodate Muslim spouses. The first one was 2004, Daniels versus Campbell. It was a de facto monogamous marriage. The question was whether the wife could inherit in terms of the Interstate Succession Act and whether she had a claim for maintenance in terms of the Maintenance of Surviving Spouses Act. Now, in this particular case, and it was Judge L.B. Sachs, he just said, well, we can give a broad interpretation to the meaning of spouse to include Muslim women because the word spouse is not defined. And spouse doesn't have to be a valid marriage in order to qualify as a spouse. And besides, it will be unconstitutional to say that certain spouses are recognized and others not. And so he used the equality principle. And eventually, he did a reading in of those two acts to say that it also includes Muslim wives or Muslim spouses. But that was just with regard to monogamous marriages. And then in 2009, this was followed also in the Constitutional Court, Hassam versus Jacob. And here it was a polygynous marriage. And the question was also, can more than one wife now claim succession in terms of the Interstate Succession Act and maintenance in terms of the Maintenance of Surviving Spouses Act if a husband dies? And the court again said, yes, well, it will be unconstitutional if you say that more than one woman in a polygynous relationship cannot inherit, but just one wife can. So also, the court also used the equality principle eventually to decide that these two acts should be extended to polygynous marriages. But again, it was done without recognizing the validity of the Muslim marriages. It was just an extension or a development or a reading into those two acts to make provision for Muslim wives as well. Now, as I already said earlier, discussions on the recognition of Muslim law in the early 1990s were there, but those discussions were abandoned because it did not enjoy the support from the broader community. And then after 1994, the debates revived. due to Section 15 of the Constitution that opened the possibility for the recognition of other religious marriages. So in 2003, the Law Reform Commission published a report on Islamic marriages, and it had a proposal for a draft bill, but nothing further happened. So in 2009, the Women's Legal Center applied for an order in the Constitutional Court to compel government to enact legislation. But then the court said, no, it's the duty of Parliament to enact legislation, and this application failed. But soon after that, in 2010, the government published a Muslim marriages draft bill for comment. Nothing happened again. In 2018, the Women's Legal Center went to court again, but this time to the Cape High Court to force government's hand. So at least there was now a bill that they could say, well, please enact it. And this time the state, the court ordered the state to enact legislation within 24 months. Now, move forward to the 2020 current position. The state appealed this particular decision. They gave arguments in September this year, and judgment has been reserved. So for now, the whole process remains in limbo. Life partnership is the other example. This is a worldwide phenomenon, also in South Africa. We don't have any statistics because that's not something that the state keeps the statistics on. There's no regulation and generally no protection of parties in case of dissolution of this partnership. Now, from 1998 to 2006, the South African Law Reform Commission also did an investigation, and this ended in a report on a domestic partnership and also with a recommendation for a bill. This was never implemented. Case law followed with different outcomes for same-sex and heterosexual partners, and I give just a few examples. 2005, there was the Forks case, in which the Constitutional Court refused to recognize a life partner in a heterosexual relationship as surviving spouse for the purpose of interstate succession. So it's quite interesting. It recognizes Muslim marriages, but it doesn't want to recognize heterosexual partnerships. And the reason the court gave was that there was no legal duty of support between partners, which can be extended after the death of one of the partners. Now, in 2006, this was followed by the Gory case, also in the constitutional case, and this time it was same-sex partners. They could not get married because at that stage the Civil Union Act was not in operation yet. The court found that this was unfair discrimination and said that they must be regarded as spouses for the purpose of interstate succession. So we have this double situation now where heterosexual partners was not regarded as surviving spouses, but same-sex partners were. In 2006, the Civil Union Act followed that allowed for same-sex partners to get married. In 2017, there was a case again, Loubser, where the court said that the Civil Union Act did not amend the Gary versus Culver case. Now, in that case, it was also same-sex partners who was allowed to inherit interstate. So despite there being an act now that allowed them to marry, the court still said, well, I'm bound with the stare decisis rule and I need to follow the Gary case. And the legislature should have said if they didn't want it to be this way. Now, I feel that this is quite an interesting development. The court did admit in passing, I agree that an inequality may exist between opposite-sex permanent partners and their same-sex counterparts by virtue of the Gory order. The question is whether same-sex permanent partners ought to be deprived of the Gory benefit. So the court did acknowledge that there might be an equality problem, but it didn't take it any further. So quite interesting, in September this year, there was a court case, Buanya versus the Master, that recognized heterosexual partners for the purpose of interstate succession. And this is quite an interesting development. So I'm going to say a little bit more about this case. It was delivered in September 2020, so it's quite new. The High Court was supposed to, if it followed the stare decisis rule, follow the judgments that said that heterosexual partners cannot inherit interstate from each other because they must marry if they want to have protection. So why didn't it follow the Constitutional Court judgment? What the court said is we can deviate from other judgment if we can distinguish the facts of the case. So what were the facts of the case? The applicant in this case was a domestic worker who didn't earn much. The deceased was well off. He had property in Kate's Bay, that's a very wealthy part of the Western Cape, and another property in Cape Town, and also a considerable amount of money in his estate. They met in 2014 while she was waiting for a taxi. He gave her a lift, they immediately clicked, and they went for dinner the same day. After this, they met regularly, and after 4 months, she moved in with him. She became responsible for the household and he paid all the household expenses. Eventually, he asked her to marry him and she agreed. However, custom required him to pay lobola to her family before they could marry. She was from Zimbabwe. 2 months before they were supposed to travel to Zimbabwe to finalize the lobola arrangement, he died unexpectedly at the age of 57, and he also died without a valid will. Now, the applicant claimed the following, that she was the interstate heir of the deceased and that she can claim maintenance from this deceased estate and in terms of the Surviving Spouses Act. Now, this is quite an interesting act. I might just mention that South Africa doesn't have the legitimate portion of a surviving spouse. We actually discarded that long ago. And then in its place came the Maintenance of Surviving Spouses Act. And this particular act protects surviving spouses who is in need of maintenance after the death of the deceased. So if she is somebody who can provide for herself, she doesn't have a claim. But if she is somebody who cannot provide for herself and the husband disinherited her, for example, in a will, she can use this act to claim maintenance from the deceased estate. Now, her argument was that there was a mutual duty to support between them and that there was no rational basis for affording same-sex partners similar relief as married spouses, but not heterosexual partners, simply on the basis of the option to marry theoretically being available to heterosexual partners. Now, before the case was heard, the parties reached an agreement, and the court was asked to continue with the issues in the case, despite the fact that they've reached an agreement. Now, the question was, if the Interstate Succession Act and the Maintenance of Surviving Spouses Act apply to a life partnership such as this one. And the court acknowledged that both acts required that there be a legal mutual duty to support. And it found that the facts of the case proved that there was such a duty to support. And the next step was then to determine if her exclusion was unconstitutional. And the court found that there was unfair discrimination based on marital status, equality, and human dignity, which could not be justified, and that she should be regarded as an interstate heir. Also, it was not bound to the Constitutional Court judgments because they dealt with same-sex marriages and not heterosexual ones. And with regard to the question if she could claim maintenance, the court said, well, in this case, we are bound to the Falk's decision and we cannot deviate from it. So she's not allowed to claim maintenance. And because the case involved the invalidity of the statutory provision in terms of the Constitution, it had to be sent to the Constitutional Court for to be confirmed, and this has not happened yet. So there is a possibility that the Constitutional Court can disagree with the order of the court and then reverse the decision. So at this stage, it's also in limbo and we don't know exactly what is going to happen. But it's an interesting approach to see how the courts are trying to get away from this responsibility not to follow other court cases when a court thinks that it will not be in the interest of justice. Now, other challenges of plurality, the most obvious one, I think, is registration. our statistics are fairly unreliable when it comes to customary marriages. But if you take the same period as customary law, for example, Statistics South Africa from 2003 to 2018, there were more than 2 million registrations. Civil unions could only be registered from 2006. So in 2007, registrations began. There are about 11,000, so it means about 1,000 plus per year. And customary law, Statistics South Africa says there are about 105,000 registered, but Home Affairs statistics, I know, almost double that. And if you consider that more than 16 million people live in terms of customary law, this number could not be reliable. So it either means that the statistics are unreliable or that people that marry in terms of customary law don't register their marriages. Now, the problem usually comes in when a husband dies and his wife or wives want to inherit. And if there is a divorce and other wives come to the fore and say, oh, but we were all also married to him. And one example is MM versus MN. It's a 2013 Constitutional Court decision. Here the wife discovered that her husband had a second wife when he died, and she also wanted to inherit. So she challenged the existence of the second marriage. None of them were registered. So there were 3 court decisions, 3 different conclusions. The first court case in the High Court said both marriages need to be registered. The second in the Supreme Court of Appeals said no, just the first marriage is valid. And then it went to the Constitutional Court, and the Constitutional Court said, yes, it's true, only the first one is, but for different reasons. And it also amended the Tonga rule, which said that the permission of the first wife is not necessary for a husband to conclude the second one. And it said, no, Tonga law needs to say that the permission of the first wife is necessary for follow-up marriages. So that is why the second one was not valid. Other problems with registration, for example, sham marriages, especially in the customary marriages domain. Immigrants wanting to come to South Africa just pretend that they concluded a customary marriage. No registration is needed, so there's not really a way to doubt this. And then, of course, practical problems for the Department of Home Affairs, which say it's difficult for them to determine the status of a person if marriages are not registered. Other challenges is the challenges of dual marriages. 2 examples, for example, where a marriage was in terms of state law, the civil marriage, and one in terms of Muslim law, the non-state law. And in Ishmael, in 2007, the person or the husband concluded his first marriage, which was a civil one, and then he also concluded a second one, Muslim marriage. And it's probably because he couldn't marry a second time in terms of civil law, because civil law only allows for one marriage. So then he decided to talak his second wife and wanted to evict her from the home. And she went to court and she said, well, he cannot do that. We had a Muslim marriage, and the court did not recognize the Muslim marriage, but said that her rights to property must be protected. Anyway, doesn't matter if the second marriage was not regarded as a valid marriage or not. In the Musa case, a similar approach in 2018 Constitutional Court. He also had 2 Muslim marriages, but then he converted the one Muslim marriage, the first one later, to a civil marriage. And he had to do that because he wanted to get a bond from the bank. And the bank required that you have a registration certificate where you say or prove that you are validly married in terms of civil law. So when he died, he had a will and he said both spouses must inherit equally, and that was accepted by the master who did the administration of the deceased estate. But then the deed office refused to do it and said, well, the Wills Act only allow for one wife, The second one was not registered, so it cannot happen. And then the court held that the Wills Act was unconstitutional because it unfairly discriminated against the wives, and it ordered that the property be registered in the name of both spouses. What is interesting is that bigamy is still an offense in South African law, but that was not even mentioned by any of the two decisions, because strictly speaking, if you have one civil marriage and you marry again, that is bigamy. So would be interesting to see what happened with the offense of bigamy. Is still going to be an offense in future or not? It can also happen in the case of civil and customary marriages. Now, in this case, both are state law. The recognition of customary marriages says that not enter a later civil marriage, except if that civil marriage is with a spouse that is already in a customary marriage. But then, of course, he cannot have further customary wives. And what's interesting in the Ramohofi case in 2017, that also ended in the Constitutional Court, here the deceased married 5 times. 3 customary marriages, 2 civil marriages. Now, the first civil marriage ended in divorce, and the second one was declared null and void 14 years later by another court when one of the customary wives complained. Now, this second wife claimed, well, if it's not a civil marriage, then it must be a customary one because we have been together as husband and wife for a very long time. Although the court only dealt with the constitutionality of certain provisions of the Recognition of Customary Marriages Act, the court did not make any pronouncements on the validity of these marriages. It just declared one of the provisions of this Marriage Act unconstitutional. It does illustrate the challenges we have with the spouses mixing the existing laws, both state law or state law and non-state law. So that brings me to the question of a single marriage code. So I think if we look at all these challenges, it is obvious that we should have one marriage code that applies to all types of relationships in South Africa. The 1962 Act was only this one act. That was followed in 2000 by a Customary Marriages Act, 2006 by heterosexual and same unions. In the pipeline is Muslim marriages, and others are soon to follow. Hindu community already said, well, if Muslims can have their own act, we want our own act as well. And it's extremely difficult to manage this diversity, as I've explained with a few examples. Now, if you look at India, for example, they also have various laws that regulate marriages, and they also faced with similar challenges. They have a Hindu Marriages Act, a Special Marriages Act, which is a protection act for everybody, a Parsi Marriages Act, Indian Christian Marriages Act, Muslim Marriages Act, in terms of custom, which is allowed by the Muslim Personal Law Shariat Application Act. And if you read the case law on India, it's always about 90% of the case dealing with what law is applicable and 10% the real issue of a marriage law. And what also happened is that people try to convert between their religions to get the advantages which they think is the advantage of one of the other religious marriage laws. So it is not a problem that's unique to South Africa. It is a problem, as Nina said, that's going to appear increasingly in Europe, which are actually used to one form of marriage. And now suddenly the influx of immigrants, people forming communities in Europe and wanting their own type of marriages recognized. So in 2013, the Minister of Home Affairs were particularly worried about the practical implications of managing all these different types of marriages and getting the statuses of people in the database of the department. So they asked the Law Reform Commission to investigate the possibility to adopt a single marriage code. But it took another few years before this was approved by the Minister of Justice and the South African Law Reform Commission. So in 2017, it was approved. In 2018, the advisory committee was chosen and I became a member. And as Nina said, in 2020, I was nominated as chairperson. And in 2019, we published the first issue paper for comments. It received 48 responses, and the issue was divided, or the viewpoints were divided on the issue of unification. So in 2020, we completed the next issue paper. We worked in all the comments. This will be considered by the Law Reform Commission tomorrow, and if it is accepted, it will be published for comment in January 21. So I need to add a disclaimer. Might happen that it is not, although it's usually just a rubber stamp that is given. So hopefully it will be approved tomorrow. Now, there's also cooperation with the Department of Home Affairs, who is currently developing a marriage policy that has not been published yet. It's also in the process of being discussed. And our recommendation is in line with global trends to favor a single marriage law. And what we've done is we added a draft bill, Protected Relationships Bill. And as far as I know, there are no other piece of legislation worldwide that contains the same title as this one. So if it goes through, eventually it will be quite unique. Now, the Protected Relationships Bill, for that we considered three options. To keep the status quo with a different statute for each type of marriage and then add on as marriages devolve. And also in the second place, a single marriage statute with a unified set of requirements for all types of relationships. And thirdly, a single marriage statute, but with different chapters dealing with the requirements for different types of relationships, which is also sometimes referred to as an omnibus statute. And eventually we decided to choose number 2. Now, the Protected Relationships Bill has a broad title. It is to include all types of relationships worthy of legal protection. Our object is to rationalize the marriage law, to prescribe a minimum core validity requirements, to provide for registration, and also to provide for formal recognition. There's a neutral definition for a protected relationship. It's any existing marriage, the 3 acts that already exist, plus religious marriages that's in the pipeline, and then also life partnerships, which will include same-sex and heterosexual. So the consequences of the relationships, and that's important to note, are not regulated by this bill or any by this bill, but by other statutes. For example, the Interstate Succession Act, Wills Act, the Maintenance of Surviving Spouses Act, Matrimonial Property Act, Divorce Act, and so on. And it's usually the meaning of spouse in those legislation which are problematic. So it will be necessary eventually to go to all that legislation and then adapt the meaning of spouse in those acts if the Protected Relationship Bill is eventually adopted and transformed into legislation. We have decided on minimum core validity requirements. So if you don't comply with that, it will be null and void. 18 years and older, free and informed consent, and the capacity to enter into a relationship. So it's very minimal. If you just comply with that, you are involved in a protected relationship. Registration remains problematic, and I will return to this. Now, just quickly looking at minimum age, it's a global problem. 600 to 15 million girls alive today were married in childhood, statistics provided by UNICEF. It's especially a problem in sub-Saharan Africa. 30%, for example, in sub-Saharan Africa married below the age of 18. There are also statistics with regard to Niger, Central African Republic, Chad. So you can see the numbers are quite high. If you look at the African continent, it's also a problem, and this is just a sample of a few of the countries which the Center for Human Rights in 2018 did a report on. 2 of our neighbors, Malawi, 50% married by 18, 12% married by 15. Mozambique, for example, our direct neighbor, 48% married by 18, 14% married by 15. If you look at the South African statistics, it doesn't look like that bad. 6% married by 18, 1% married by 15. And I'm not so sure that these statistics are 100% correct. It's also only based on a sample, and it's especially in the customary law setting where the marriages could be quite higher below the age of 18 that is indicated in this percentage. So that is why we decided that it is not negotiable. The minimum age is 18 years. That's also the age of majority in South Africa. And the recommendation we are making is that no person or institution can provide consent for any person under the age of 18 years. So it will not be possible for a parent or a guardian to give permission to an underage person to get married. And we did that because we want to prevent arranged marriages between minors. I suppose this is also going to be a quite controversial provision in the bill, and we expect a lot of comments on this. The second one is consent and capacity. That is quite standard. Capacity to understand the legal consequences of relationships when it was entered into. With regard to consent, there are 3 scenarios. We have the examples where marriage officers were involved. They usually need the signature of 2 witnesses in the presence of everyone to cover this consent requirement. And then there's also a controversial one where a proxy is involved, and that is usually in the case of Muslim marriages. So we expect that this is also going to be controversial. We at the committee also did not agree on giving a proxy. Where you get the situation where no marriage officers are involved, it will be the responsibility of the registering officer, and that would usually be by, at the Department of Home Affairs that determine if there were consent or not. So there will be procedures in place to make sure that consent was present. Registration is the other problem. If you look at international documents, Convention on the Consent to Marriage Minimum Age 93, and also CEDAW, which South Africa ratified in 95, and also on a regional level, the African Charter on the Rights of and Welfare of the Child, which South Africa ratified in 2000, registration is required. Many African countries also require it, although a few say that registration must be voluntary, such as Ghana. The Department of Home Affairs would prefer that registration is also a requirement to get certainty in this area. But we did not agree on this, and eventually the proposal is that all relationships must be registered, either by the marriage officer, a traditional leader, if it is customary law, or spouses themselves. But failure to register does not lead to the invalidity of the relationship. So we expect that this is also going to elicit a lot of comments from the public. So what is going to happen now? The Law Reform Commission proposes this secular statute that prescribes the core requirements for a relationship to be a protected one. If it is not a protected one, the normal consequences for marriages and relationships will be applicable: maintenance, divorce, property, and so on. That consequences are regulated by common law and statutes, so we need to work closely with other Law Reform Commission investigations, which are currently going on, maintenance, property, and divorce, and they should also look at our proposals, and I suppose we should also look at their proposals. The draft bill will be published in January for comments, and all the recommendations will then be considered, and probably a final report, except if the comments are too controversial, will be published in the middle of 2021. So in conclusion, this unification is for practical reasons, but also to protect vulnerable spouses and children. It is not easy to unify when we were already on the road of diversity, and when this diversity is celebrated and encouraged by a constitution. So we have a long and difficult road ahead of us. Thank you for listening.